Hey, what's going on, guys? This is Adam D'Angeli from Rescue Michigan. We are live on YouTube, Rumble, and Facebook. This was an unannounced stream. We didn't do any emails about it, didn't do any promotion about it. Just a video I wanted to make. It is Thursday, November 18th. The Kyle Rittenhouse jury has been deliberating for 3 days, and there's a good chance they're going to reach some kind of verdict tomorrow, because if they don't, they're going to have to adjourn for the weekend, come back on Monday. They're going to start thinking about their Thanksgiving plans. So I wanted to talk about all of the amazing things I've seen in this trial, and especially the things I've seen from Kyle's defense attorneys. Just unbelievable errors, unbelievable avoidable errors, things that even someone like me, who's not an attorney, can point out fairly obviously. Now, I may not be an attorney. I have played one at the Capitol for several years, and I have a little bit of personal experience in this stuff. I actually won a trial against me with a jury and no attorney representing me. It was a small thing. If you're wondering what I did that led to a trial, it was a noise violation, and that was all. Nevertheless, I actually contested a noise violation, demanded a trial by a jury, and actually won. So I've got that teensy bit of experience here. That being said, obviously, because I'm not an attorney, we have to at least give Kyle's attorneys the benefit of the fact that we're not the ones in the arena. I'm the one Monday morning quarterbacking on this. I'm not the expert. There may be things that I personally don't know that they do that informs what their behavior is. But as we go through these 20 things, 20 enormous things, I think you'll agree with me that it's hard to understand how the defense could have made so many terrible mistakes. But let me know if you're watching on Facebook, YouTube, Rumble, leave a comment. Actually, I don't have Rumble pulled up right now, and I'm using all three of my screens at once, so I can't see the chat in Rumble. And in my experience, we haven't had chat in Rumble anyway, but I believe I do see chats in Facebook and YouTube live on the stream. So if you can't hear me or something, or there's anything going on, let me know you're here and you're watching. Otherwise, yeah, feel free to leave a comment, and I will try to answer them. I don't know how long this is going to go for. I've got 20 things to go through, so I imagine I'm going to be here for like an hour or so, but we'll see how it goes. But I wanted to make this video to document this, because tomorrow there's a good chance we're going to see some kind of outcome in this trial. And I think it's important now. We've been on edge. And I should point out, this is an absolutely critical trial for the right of self-defense, for the right of people to have a fair trial that's not subject by tampering from Antifa, Black Lives Matter, and outside groups that are supposed to be prohibited from interfering with the trial. You know, all the notions we have about sequestering juries, admissibility of evidence, all of this stuff is supposed to prevent the tampering of a trial from outside forces. And what we've seen happen in this trial is the exact opposite. We've seen the active poisoning of the jury pool, particularly with the local media in Kenosha and the national news media, where for the past year we've seen almost entirely negative coverage from the mass media and almost no coverage whatsoever from the conservative media. Just as one example. I looked at some news article in a left-wing media source, and the reporting was Kyle Rittenhouse, a white man, is facing trial for the shooting and killing of 2 people, shooting of 3, killing of 2, in response to the protests regarding Jacob Blake, a black man the police shot. And there were so many liberals on Twitter and elsewhere who assumed that the people Kyle shot were black, which they were not. The amount of disinformation around this trial coming from the media has permeated the entire social media space everywhere, to the point that people, especially people on the left, have all kinds of misconceptions about the case. Everything from he crossed state lines with a rifle, which he didn't. His mother drove him across state lines, which she didn't. The rifle was illegal. It wasn't. And the list goes on and on and on. But right now, the jury is still deliberating, and that is because of the first and probably the worst mistake that Kyle's attorneys made. So we're going to go through them now, actually. The top 20 ways Kyle Rittenhouse's lawyers failed him. Number one, they failed to adequately screen the jurors. And what makes this so egregious is that his lawyers actually had a whole team on standby willing to work for free to perform this essential task. So the way it works, at least in Wisconsin, is that the lawyers are made aware of the names of the potential jurors a week before they actually have their voir dire. That's the hearing where they decide who is and is not qualified to be a juror. And Kyle had a whole team on standby. They were going to go through their social media profiles, go through their political histories, look for data brokers for any information they had on them, look for demographic information, look for whatever jurors might be a problem for Kyle. Because one of the people that they had was Richard Barris, who runs People's Pundit. He does extensive polling, and he did polling in Kenosha. And what he found was that an average Kenosha jury has about half of the people who have a negative predisposition toward Kyle, and many, I think it was something like a third of them, have an absolutely firm negative disposition toward Kyle, who would not move away from having prejudged him guilty before anything even started and could not be moved by any amount of evidence. And that may seem strange to you. It's not if you understand how people think, how we form our opinions. People are more psychological, more social, more emotional than we actually are intellectual. And when people form a firm opinion, and especially if they've had the opportunity to become personally invested in that opinion. For example, if I tell my family and friends what I think about Kyle Rittenhouse, now they have a firm psychological conviction to that opinion. And when you have a firm psychological conviction to an opinion, the facts cannot change it. Exhibit A, how many of you have friends and family you absolutely cannot change their opinions about politics on, regardless of their political dispositions, regardless of the facts you bring, regardless of anything you say? That's the power of bias. And Kyle had the opportunity to have the entire potential pool of jurors screened to know exactly who should be removed and to make sure that anybody who was a political activist, anybody who was absolutely personally committed to Kyle's guilt, or anybody who even was likely to have that disposition was removed from the jury. And what actually happened the day before jury selection began, or maybe it was 2 days before, but whatever, it was right before it happened. Kyle's attorneys literally fired them all. They weren't, I mean, and I say fired, they were working for free. They were working for free. They offered this because they knew how important this was. They understood the gravity of the case. And yet, Kyle's attorneys apparently didn't want them stealing the spotlight. There was concerns that some of the other volunteers would, have criticisms about their legal style, all the rest of that stuff. They fired them all. And you could tell, and lawyers have observed, people smarter than me have observed, that what they appear to have had in the trial is a random jury, essentially, meaning they have some percent of people that went in there thinking he was innocent. They had some percent going in thinking he was guilty. And some of those people thinking he was guilty from the get-go could not possibly be moved. This was absolutely avoidable. And the reason why the jury is still deliberating right now, well, not right this instant, but this whole day and yesterday and the day before, is because they didn't screen the jury properly, which they could have. They didn't just fail to, forget to, didn't think to. They actively sabotaged, stopped, fired the attorneys and the experts, the pollsters, the people who understand psychology, the people that were volunteering to help them. They refused to let them help. And that's why we have the jury that we have. So that is the biggest thing, and that is what is the most potentially fatal mistake they made. And they made this on the very first day of the trial, jury selection. All right, number two, failure to expose jury bias. And this goes to the judge now. We're talking about the judge's overall impression of the jury, how he views the case. And this is a judge, if you've seen the case, if you've seen this, it's his last name's Schroeder. I think it's Bruce Schroeder, whatever his first name is, Schroeder. Very old guy. He's been a judge for over 40 years. He doesn't understand social media. In fact, a lot of things in the trial have led to exposing how he really doesn't understand technology at all. And when this judge first took the bench, there was no imagining the degree of tampering with the trial that we see today in terms of social media being able to send facts or false facts, opinions all the way around the world, all the time in real time. And there was no understanding on the judge's part that the actual public polling in Kenosha showed enormous problems with the jury. For one thing, the polls showed that 80% of jurors, 80% of the people they polled, which in a random jury means probably around 80% of the jurors, had a real concern that the verdict they would reach might have negative consequences for either themselves personally or their family or the community, which is what, younger people like me, and I'm not that young, but compared to the judge, would expect. Because they've seen, first of all, what happened in Kenosha. The riot in Kenosha was the result of Jacob Blake being shot, rightly, according to the courts, by police. Why was it considered a justified shooting? Well, let's see. He was being arrested for a felony warrant. He was in the act of kidnapping his children. And then he went into his car to grab a knife, rolled around the cops with a knife in his hand, and the police shot him. Non-fatally. And without the facts, without the law, Antifa and Black Lives Matter decided that something bad happened to a black person, regardless of the facts, regardless of the circumstances, and so they decided to burn down the city. So anyone understanding what happened at that moment understood that they had a real problem with acquitting Kyle, because the same thing could happen again. And the judge was never informed of this, because that would have completely changed how he would have looked at the case. And you can see this through so many of the decisions he made. He trusts the jury. There was a number of instances when there was objections to evidence. And frankly, there's a lot of cases we'll talk about where there was a lack of objections to evidence, but there was a lot of objections to evidence where the judge said, let it in, let the jury decide. Had that judge understood the problems with the jury, that the jury was concerned for their personal safety, that the jury was concerned for their community safety, that the jury had likely have jurors on it that were predisposed against Kyle, he might have ruled on a lot of different matters very differently. The lawyers didn't think anything about this, or if they did, they didn't do anything about it. Number 3, failure to demand dismissal for multiple constitutional violations. Now, the big story yesterday was Kyle's defense did file a motion to dismiss with prejudice, or a mistrial with prejudice, which is effectively dismissal. A mistrial with prejudice means this trial cannot be rebrought anymore. It is final. The prosecution screwed up. They violated Kyle's rights. They can't get another bite at the apple, period. Now, it's nice they filed that motion. It was a 7-page motion. It was by far incomplete. And it was by far not rhetorically forceful at all. They did point out, rightly, that the judge snapped twice at the prosecutors. First, for improperly trying to attack Kyle for exercising his Fifth Amendment rights, which is absolutely improper. And then again, for attempting to introduce evidence that the judge himself said they couldn't bring. And both of those happened when Kyle actually was on the stand. And they used this as a frame to say, we've seen bad faith on the part of the prosecution. And they made the point that the real thing was the prosecution altered evidence and withheld evidence from the defense to impair their ability to defend Kyle with the full advocacy they should have. And that's an absolute right of the defendants. The problem is they absolutely did not follow through on that motion. They had a hearing on it yesterday. And the judge was clearly siding, at least leaning, with the defense. He was questioning the video, was questioning why the prosecution had a different version of the video than the defense had. And the prosecution filibustered them with excuse after excuse. Oh, sorry, it must have been a mistake. It must have been a mistake. It wasn't a mistake. And even if it was a mistake, that doesn't excuse it. It's the prosecution's responsibility to bring that evidence to the defense faithfully and accurately. And interestingly, with every other piece of evidence they did, but not with that one piece of evidence, the video on which their entire case rests, a completely illegible, blurry picture of Kyle that they claim shows him pointing a gun at somebody that you cannot see. And the defense did almost nothing to push back. And this is yesterday. It's after 2.5 weeks of trial. And there's been this pattern of the prosecution basically just talking and talking and talking and getting the judge down from his anger. And then the defense not pushing in, not pushing back, not really demanding it. The judge yesterday, even at one point, said, I feel like reckoning day is coming. And the defense could have said, this is reckoning day, judge. This is it. The prosecution lied to you about this evidence. They lied to you about multiple witnesses. They lied to you about Jump Kick Man not being available. They attempted intentionally to attack my client by violating his rights more than once. This has happened over and over again. Judge, dismiss this case now. And had they laid that foundation I talked about earlier about the jury pool being biased in an improper manner, they might have actually gotten that dismissal right there and then, but they didn't fight for it. Failure to build a narrative. This is a problem the defense has had through the entire case. They have been, and we'll talk about this in detail, in the opening statement, in the cross-examination of witnesses, and in their closing statement. They never properly framed the narrative about who Kyle is, what he was doing that day, why he is so completely innocent and in the right. Some of these things you think, well, you kind of got there through testimony and you kind of got there through things they said. But for example, one thing the defense never said, and Robert Barnes said this very well, Kyle's innocence is what brought him to Kenosha that day. He couldn't imagine someone would actually attack him for administering help. The reason why Kyle came to Kenosha was to clean up graffiti, to help people that might have been injured, to do anything, to put out fires. And it was his innocence that led him not to understand why that would be such a bad idea and why he should just stay home. He wanted to protect the city. And it was only in the very last moment when his life was in mortal danger that he pulled that trigger. And that's true in every single instance. They never really laid it out quite like that. And they never laid it out about the contrast between what everybody else there was doing in Kenosha. They were there to burn, they were there to loot, they were there to destroy property, they were there to kill people. And Kyle was their target. Here's what they never said. Those people that the prosecutors want to call victims were not just assailants. They were co-conspirators. They were conspiring to murder Kyle Rittenhouse. You had, what's his name? Zeminski. I forget the first name, but you had Zeminski and you had Joseph Rosenbaum working together. Rosenbaum told Kyle, I'm going to kill you when I get you alone. And they stalked him until the moment when he was alone. That was when Zeminski fired his gun in the air. That was when Rosenbaum lunged at Kyle. They never really laid that out, not explicitly enough. They didn't do narrative building well at all. They laid out the facts. They didn't tie them all together into a full story. Failure to expose manipulation. And I talked earlier about the manipulation of the jury. But the manipulation of the prosecution, I mean, this is where, this is a simple technique. This is a technique I use in politics all the time. The technique I used in my own trial. One of the most powerful things is you show the audience, i.e. the jury, and to some degree the judge, how the other side is manipulating them. You point out what they're doing. For example, in my trial, the prosecutor started questioning me. He says, what do you do in your business? And I say, well, we sell this and this and this. He says, well, wait, you sell spray paint, don't you? I say, yes, we do. He says, you sell spray paint to graffiti people's walls, don't you? And I say, no, I sell spray paint because spray paint sells. And then later on in my close, I say, look, I could have objected to that because it had no relevance to this case whatsoever. We're talking about a noise violation here. Why is the prosecutor talking about the fact that I sell spray paint? And rather than object to him, jury, I want to just point out to you The reason why he brought that in is to assassinate my character because we know they have no case. And frankly, jury, it shows you that the police had animus to me. That's why they wanted to give me a noise violation, because I sell spray paint and because they see the spray paint that I sell to my customers to make money causing them to do graffiti. Or not causing them, but they do graffiti, and they blame me for selling it to them. So I want to point out to you, ladies and gentlemen of the jury, how biased the police and the city were against me. And I was acquitted, by the way. I won. That's the kind of thing you want to point out. And I can think of a great example of that, although it's coming up on another slide anyway. And that's the example of the prosecution trying to say Kyle lied about being an EMT. But we'll get to that in a moment here. But that's the kind of thing that's perfect, because the prosecution was doing these psychological games with the jury the entire way through. And the defense only talked about facts. They didn't really get into the law. They didn't really get into the motivations. They didn't really get into how exactly the prosecution was bringing in things that had no relevance to the case just to attack Kyle and just to attack some other witnesses. Like, for example, Drew Hernandez. They tried to attack him for being a political website. They could have slammed on that. You were attacking Drew Hernandez for running a website that happens to have a bias, but bias is not the issue here. And you're telling the jury, this is a political case. Otherwise, why would it matter? He's here to tell you what he saw, and he's here to tell you what was on his videos. And again, they didn't hit on that well enough at all. Failure to make a strong opening. Their opening statement was weak. This is Mark Richards doing the opening and the closing, and he's this Kenosha lawyer. He's got this really thick Wisconsin accent, which is like somewhere between Illinois and the UP. Ladies and gentlemen of the jury. I mean, and again, it was not much of a narrative. It was facts, facts, facts. The facts will show that my client acted in self-defense. And that's not a very good Kenosha accent. I'm not from Wisconsin. But anyway, it was about 45 minutes. They did use some video evidence, but they didn't use the best video evidence. They didn't use the evidence. They could have played to the nth degree of the burning and the looting. They didn't use video of, I don't know, someone being beaten in the streets the night before. And what we found out further on the trial is the judge had the inclination to allow things in. Even if they said, oh, this is even if the prosecution objected to it, the judge was likely to allow it. And the defense attorney should have known this. Mark Richards was a prosecutor in Kenosha. They didn't understand the judge, and they didn't make the strong narrative case in the opening statement. It was facts and facts and facts. And that was about it. The closing was worse, but we'll get to that. All right, number 7, failure to impeach Anthony Huber. The funny thing is, the defense throughout the trial rarely objected when they really, really, really should have. And one of the few times they did object was the worst time to object. It was a moment when Anthony Huber, now Anthony Huber, if you don't know who I'm talking about, Anthony Huber was the guy that attacked Kyle with a skateboard. He was the second one shot and killed. He is actually, interestingly, convicted of battery. He had actually threatened to stab his brother. He'd beaten his sister. He was actually also arraigned for kidnapping somebody. He's a sociopath. And he was the one that, along with so-called Jump Kick Man, although his name came out, it just came out today. I don't have it handy, but throughout the trial, they were calling him Jump Kick Man. Kyle was running towards the police. It was after shooting Joseph Rosenbaum. And Anthony Huber and Jump Kick Man and a whole crowd of people were chasing down Kyle. And the Jump Kick Man kicks Kyle in the face, knocking him down. Anthony Huber closes in with a skateboard, has the skateboard up, is ready to swing it down on him and crack Kyle's head open with it. And that's Anthony Huber. So Anthony Huber, the prosecution brings his great aunt to testify what a great guy he is. And so they're telling him, she's talking about his family life, and he said this, and he did this, and yada, yada, yada. And at the moment when she starts saying he was a good kid, defense says, objection, Your Honor. This is character evidence. And here's the problem with this. If they had let the prosecution go on and do as much as they wanted with Anthony Huber's aunt, the defense could have cross-examined and say, isn't it true that Anthony Huber was arrested for then the defense can start using character evidence. But because the defense objected right there and then, the judge said, yeah, this is character evidence. Now, if they let it go, the defense could have said, Your Honor, this woman has no probative evidence in the entire case. The prosecution brought her just for character evidence and for no other purpose. And she said, oh, he was a great boy and he wanted to be a doctor and yada, yada, yada. And then they could have impeached that testimony. They never did it. By the way, the other thing that they didn't do is bring in any kind of expert to talk about Anthony Huber's skateboard. And is a skateboard lethal? Well, a lot of jurors probably don't know the answer to that question. The answer is, of course it is. Of course it is. You've got these metal trucks that connect the board to the wheels that have to be really, really sturdy because skateboarders jump on them and they don't want them to break because it'll injure them. So they're made of typically steel or else some kind of very hardened polymer. They didn't have any expert to talk about that. Or maybe they did, but they got rid of him. We'll get to that in a moment. Calling Kyle to the stand. Every lawyer talking about this case has said this was an extremely risky, extremely dangerous move because anything Kyle could have said could have been devastating to his case. Anything. And you just don't know until after it happens and it's too late. And all of the attorneys had said, you know, this is an extremely dangerous move. I would never advise my client to take this stand in this kind of circumstances. As it happened, Kyle's testimony was as close to perfect as anybody could have imagined testimony being. And yet, even still, it gave the prosecution a foot in the door. First of all, it kept the trial going a day longer. And it allowed the prosecution to get some last-minute evidence in, which compromised the defense's entire case. And it allowed them to bring in additional nonsense against Kyle. Like, and I'll get to this in a moment, they belabored that Kyle lied to somebody about being an EMT. They allowed the prosecution to craft their narrative. And the problem with calling a defense witness to the stand is, for all these jurors, you know, some people have an open mind. Most had their mind made up one way or the other before the trial started. And what happens when you see the defendant is the people that believe he's guilty look at him as a liar, no matter how authentic and sincere his testimony is. They're not body language experts. They don't know anything about this. But look at Twitter. Look at left-wing Twitter. And you see these lunatics saying Kyle didn't even have real tears. It was obviously an act. He was obviously coached and blah, 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 and on it goes. You know, they don't. Sincere, honest testimony is not enough to change the mind of a determined juror willing to convict. And likewise, it doesn't change the opinion of someone committed to his defense unless they start polluting their opinions about Kyle based on he lied about this, he lied about that, et cetera, et cetera. And of course, it turns out Kyle didn't lie about anything. We'll get to that in a moment here. And as part of that cross-examination of Kyle, the prosecution went after Kyle for hours. And they committed so many violations against Kyle. And the defense just stood there and took it and never, ever objected. The prosecution asked the same questions over and over and over again. They were badgering the witness. That's an objectionable problem. And there was more things, evidence without foundation. It just went on and on. And the lawyers watching the trial live in real time are like screaming, object, lack of foundation. They're asking Kyle questions about how bullets work and about the length of the gun. And they're like, object, he's not an expert. This is without foundation. And it just went on and on and on like this for hours. And they said nothing. And again, this might be something where there was a tactic involved, where it was to show how strong Kyle could be under this intense duress. But nevertheless, it was bizarre. Failure to object to expert evidence without foundation. And there was a bunch of this stuff, folks. The worst of it was they asked Kyle, there's also this guy, I think his last name was Balch. He was a friend of Kyle's. He was called by the prosecution. And he said he used to be in the military. So they're asking him questions about hollow points versus full metal jacket. They're asking about what kind of firepower an AR-15 has, et cetera, et cetera, et cetera. All questions that guy is not qualified to answer. You have to be an expert in ballistics, an expert in firearms to be able to answer these questions. And again, they don't object to any of it. And the prosecution used this stuff against Kyle in the closing arguments. They say he didn't use those safe hollow points. He used those dangerous full metal jacket rounds that could have ripped through a person and shot somebody behind them. That's recklessness. And there was nobody on the defense side. They had no use of force expert. Well, they had one, but they didn't use him. I'll tell you about that in a moment. They had nobody to say, no, that's absolutely ridiculous and absurd. In a life or death situation, it does not matter whether your bullets are full metal jacket or hollow point. In fact, Kyle had no choice in what ammo was in the gun because it wasn't his gun and it wasn't his ammo. Might have actually been his ammo, but it wouldn't matter. Kyle can't be expected to know the difference between FMJ and hollow point. And even if he did, it wouldn't matter because his life was in immediate mortal danger. And of course, he actually didn't shoot anybody through the target. That never happened at all. And there was a bunch of stuff like this. There was the prosecution's star witness. Well, not star. He was an absolute moron. But the guy that they used to admit the video evidence, I'm going to get to more about the video evidence in a little bit here, was this guy at a crime lab who had no clue about how images are processed. So how are these pixels generated? I don't know. Well, should they be in red pixels or green pixels? I don't know. His answer was, I don't know. There was no Doe-Bear hearing to even determine if the guy was an expert in videography. None of this stuff. The guy says my report was peer-reviewed. That just means another guy at the office looked at it. All of this went completely unchallenged. And again, this is the evidence that the prosecution's entire case relies on, is that an infinitesimally small pixel that purports to be Kyle, which you can't even tell if it actually is, said that they claim he's pointing his gun at somebody, which you cannot see in the evidence. The judge even said, I can't see this. And yet the judge allowed the jury to make that determination, which he shouldn't have. But the prosecution, but the defense didn't push it. Is that another number 10? I got 2 10s. I guess this is an 11. Okay, this is number 11. Failure to get expert self-defense testimony from police. They had multiple police officers in this trial. They could have asked them, any of them. So, officer, if a suspect puts his hand on your gun, do you pull the trigger? Yes, of course I do. I mean, this is what happened with Rosenbaum. The experts showed that the soot that came out of the barrel of the gun was on Anthony Huber's hand, and it started like here, not like at the very end, meaning his hand was grasping the barrel, and so the soot hit one part of his hand and not the other because the other part was over the barrel. And at no point do they say to any law enforcement officer, so you have a right to shoot somebody if someone is actually taking your gun, right? Yeah, of course we do. I mean, there was no law of self-defense expert there at all. I mean, one thing that they never, ever said, they never brought up any time, which was absolutely critical, is that if someone's hand is on your gun, it's in their possession. Huber, skateboard guy, he touched Kyle's gun too. And the prosecution, again, this also goes to the framing, this also goes to the narrative. The prosecution kept trying to say, well, Kyle had a sling, so his gun was his. It was totally safe. That's BS. If someone has their hand on your gun, they are fighting you for control of your gun. You are not in control of your gun if your opponent's hand is on it. And nobody testified to that. That's an unbelievable oversight because it was absolutely relevant to Rosenbaum and Huber. The two people that were shot to death, their hands were on his gun. He was fighting for possession of his rifle against theirs because who knows what could happen. The notion that because he's a sling, the gun is permanently in his control and couldn't possibly in somebody else's control, that's absolutely untrue. I mean, we've seen the movies where people fight for control of a weapon. Maybe they could strangle him with a sling. Maybe somebody else could have taken their hands on the gun. When you are at the point where you're assailants and you are fighting for control of your firearm, your gun is partially in their possession. They never, ever said that. They didn't call their own witnesses. They could have even just asked the cops to talk about this. But no, they didn't. And again, cops really aren't experts in self-defense, but because the judge was letting all this stuff in, they could have tried it. They could have tried it, but they didn't try. And that's really the long and short of this whole case. They didn't try. Number 12, failed to debunk the narrative of Kyle lying about being an EMT. This is one of those little things that just pisses me off. Because here's where the prosecution was laying an essential part of their narrative. They were impeaching Kyle's character, and they say, look, he's a liar. He's a liar. He was asked if he was an EMT, and he said yes. He lied to you. You heard that, ladies and gentlemen of the jury. Kyle said he was an EMT. He testified that. And when he's cross-examining Kyle, this was Kyle's probably one of his only mistakes on cross-examination. He says, but you told someone you're an EMT. Yes, but you're not an EMT. Correct. So you lied. And he says, yes. Kyle should have said no. But even if he had said yes, his defense should have rescued him in closing arguments, because this is the part of the closing argument that the prosecution started out with. They started out with, and they repeated on multiple slides, Kyle lied about being an EMT. And all the defense had to say was, ladies and gentlemen, Kyle did not lie about being an EMT. He exaggerated appropriately for the moment it was happening. Hey, are you an EMT? Well, I'm not technically an EMT, but I'm a medic. I can help you. I've got a medical kit. I can do something. You know, that's all he was doing. He was trying to help. Whether or not he was an actual licensed EMT is not the issue. He was someone there to administer aid. He had a medical bag with first aid kit in it. He wanted to help people. He wasn't lying to them. Oh yeah, I'm an EMT, like he's inflating his resume or something. He was making himself available to deliver first aid. And the defense never went against that narrative. And that's so essential, because that's what the jurors who are holding out for Kyle's guilt are thinking about is he shouldn't have been there that day. He lied. His character is in question, yada, yada, yada. And they failed to debunk an important point in the prosecution's narrative. Dumb. Grievous oversight. And that leads to the closing statement in general. Now, when I first saw the closing statement, I thought, you know what? They did a good job on this. They went through the witnesses. They showed how the witnesses testified to the facts of the case in Kyle's defense. But what they didn't do, once again, they didn't do framing very well. But more importantly, they weren't speaking to the jurors that were undecided and might have been swayed. And even to soften the jurors that were against that were for his conviction, but might have given out earlier and gone with acquittal. By the way, as an aside, the jury instructions are, and this is true pretty much everywhere, is the jury has to reach a unanimous verdict, which I think is garbage, because the standard is guilty beyond a reasonable doubt. Well, if 7 jurors out of 12 think he's innocent, that's a reasonable doubt. That should be it, period. I say if you have a majority of jurors that say he's not guilty, he should be not guilty right then and there. The notion they have to unanimously get to a verdict of not guilty or guilty or not guilty on one particular charge or another is stupid, and it's unfair to defendants. But anyway, Mark Richards, Kyle's attorney, gives the closing statement, and it's all from his own perspective. He's making it in anger. Ladies and gentlemen of the jury, you've now seen how ridiculous this case is. Again, sorry, bad Kenosha accent there. But the point being, he was talking to the people who were already on his side, which is not what you need to do. And he didn't anticipate the things he should have anticipated the prosecution would try to do in their quote-unquote rebuttal. And he didn't preemptively address any of that. Worst of all, he really, actually this never ends, coming up on a future slide, but he never really laid out in plain English the standards for the law of self-defense. So in many ways, it was a good closing statement, but there were some big omissions there. And again, one of them was not impeaching that prosecution's ridiculous line about Kyle lying about being an EMT. There were some good things. There was the hocus pocus out of focus line. That was the memorable one. That was really good. But there was a lot that was not so good. Failure to use their own star witness, Dr. John Black. So this guy, John Black, he is their expert witness in a lot of things. He's an expert in use of force. He's an expert in video analysis. His resume is a mile long. And he was going to be their star witness for the whole trial. Now, meanwhile, the prosecution has their witness who's going to be their video expert and their use of force expert. The guy, they have their Daubert hearing. That's the hearing where they vet if a witness is an expert or not. And the guy is an absolute moron. First of all, the report he was supposed to write for the court, a year after the incident, it still isn't done. So it comes in like 3 weeks late. You can tell that the guy teaches at community college. He has no clue what he's talking about. He's not qualified in anything. He was an absolute moron. So guess what the defense does? They stipulate to an agreement that they won't call their idiot if they limit Dr. Black's testimony to just video analysis. And all of the great stuff he could have said about use of force goes out the window. The defense could have torn apart the prosecution's witness on this stuff. But they stipulated that all out, and they didn't get the opportunity to bring John Black on to talk about, and therefore they had no real expert to talk about what the legal standard is for use of force, to observe that everything he sees in the video is consistent with an appropriate use of force. All that got thrown out the window. Yeah, and then this is from the closing arguments, failure to adequately explain jury instructions. The jury instructions were like 36 pages of legalese. When they adjourned tonight, earlier today, I should say, after 3 days of back and forth, at least one of the jurors asks if he or she can take the jury instructions home to study them. And the observers of the trial are concluding they're having a fight over the legalese. You've got some obstinate jurors on one side, some on the other. Someone wants to take the jury instructions home to really pick it apart, probably someone committed to the prosecution, which the judge allowed, of course. And the defense should have really taken the time to explain in plain English in a way that benefits Kyle the most why the jury instructions establish an extraordinarily high bar for them to convict. Why they have to find that not only that they have to find that all they have to say is there is a reasonable doubt that Kyle didn't provoke anybody. Because that's what the prosecution's trying to say is Kyle provoked it, and that changes the whole dynamic. No, all they have to show is that there's a reasonable doubt that Kyle didn't provoke them. And if Kyle didn't provoke them, if you can't say for certainty beyond a reasonable doubt that Kyle provoked them, then we all get to go home. They did not do that. They did not clearly explain that the entire case rests on the question of self-defense. And if you determine Kyle's acting in self-defense, your job is done. They didn't do that. They allowed the prosecution to bamboozle them with all the legalese. Now the jurors that are pro-conviction have those jury instructions, and they're going to try to use that to there's another word for bamboozle. It's on the tip of my tongue. What's the word? To mystify the issue for the jurors. And the defense just clearly, succinctly conveyed to the jury what the high burden of proof actually was. Kyle would probably be home free right now. Failure to lay out a complete case for mistrial with prejudice. And again, they did move for mistrial with prejudice. They did not lay out the full case. They haven't even mentioned to the judge that the prosecution has known for months who Jump Kick Man was. They knew his identity. They failed to disclose that to the defense. That's a absolutely huge issue. And again, even though they did point out that the prosecution manipulated the video that they gave the defense, that they deliberately did not give them the evidence that they were going to rest their entire case on, that should be enough for dismissal with prejudice. And they've hinted at the elements, and the judge has shown sympathy to him, but they've never slammed the case home, and it may now be too late. Your Honor, they intentionally, and you know it was intentional, you said it was in bad faith, attempted to impeach the defendant for exercising his Fifth Amendment rights. You told them you don't believe that they didn't intentionally bring in forbidden evidence to poison the jury. You know they did. You know they poisoned the jury not once, but twice in a half hour. And you know they had the identity of Jump Kick Man. They withheld that from us so we couldn't interview him. And you know that they had the burden to do that. You've heard the idiot explanation from the prosecutor as to why the video evidence was edited, why the aspect ratio was changed, why the file format was changed, why the video quality was changed. And you know, because you've seen all the evidence, Your Honor, that this was the only time they ever did that to us. You know they've attempted to manipulate and lie to you, to lie to this court, to lie to this jury, and to lie to us, Kyle's defense. You owe us a mistrial with prejudice, Your Honor, because the prosecution intentionally did all of these things, and you know it. They never said that. They never said it. And in fact, when 2 days ago, after seeing the grainy video and determining that he can't see anything, and after the prosecution's been filibustering on this, the defense, he goes to the defense, let them have the last word. So they say, anything further? And Chirafisi says, no, we made our point. I mean, this is law. This is persuasion 101. Repetition is key. You know, I kind of mentioned this point earlier about the complete case. I brought up again. Why? Because repetition is key. And every lawyer whose job is to persuade should know that. And they just threw away an opportunity to hit that home run. Unbelievable. Oh, and then this happened. You guys have probably seen this on social media. The prosecutor, one of the prosecutors, Binger, Little Binger, we call him. If you guys don't know Game of Thrones, he looks just like this character who's known for being completely manipulative, dishonest, and evil. So we call him Little Binger. Failed to capitalize on he pointed Kyle's gun at the jury with his finger on the trigger. Now, the best thing that could have happened in that moment was a juror hit the deck, you know, but the defense could have jumped on that. Oh my God, did you just see what he did? He just pointed the gun at him. They could have made that an issue. They could have they could have belabored that in front of the jury to the judge. This guy doesn't even know gun safety. What in the world is he even doing talking about guns to these jurors? He doesn't know the first thing about gun safety. That you never point a gun in an unsafe direction, that you don't put your finger on the trigger unless you're ready to fire, and that you assume every gun is loaded unless you personally have checked it. That's how Alec Baldwin killed somebody with negligence. They could have belabored that. They could have taken advantage of that. They did nothing. And again, you know, spur of the moment, I get it. I've often after speaking gone back and thought, oh, I should have said this, I should have said that, but that was dynamite that they should have seen. Failure to address interference from BLM and Antifa. And throughout this entire trial, BLM and Antifa have tried to attack the jury. And again, one more thing the defense never brought up in their motion to dismiss with prejudice. There has been an active effort to poison the jury pool. The jurors are in fear for their lives. They're in fear for their families. They're in fear for their city. Before the trial even started, Your Honor, polling showed 80% of Kenosha residents were concerned about this. And now the concerns are being brought to life. This cannot be considered an impartial jury because they cannot divorce their real lives from their decision today. And we've seen the media attempting to identify them. Never did it. All right, it's getting pretty late, and I'm getting hungry, actually. So let's see what else we can do. This would be number 19. Failure to alert the judge on Handbrake. Maybe this is a small thing. Maybe this is a small thing. But the funny thing is, the prosecutor's evidence computer got shown to the cameras, got shown to the court, and people all over Twitter noticed something. Because remember I told you the prosecution edited the video that they gave to the defense. And they claimed, we don't know anything about videos. We wouldn't know how to edit a video. It was an innocent mistake. Oh, I hit forward on a phone message. And it's all a bunch of bullshit that the judge didn't know was bullshit because he doesn't understand technology. But when the camera saw the prosecution's evidence computer, it had on it a program called Handbrake. What does Handbrake do? It converts and manipulates videos. Why was that on the prosecution's computer? A key point that they could have probably even used to revive the issue of evidence tampering. Missed. So taken all together, folks, we've covered 19 bad mistakes that the defense made. Basic mistakes, big mistakes. Failing to figure out who's on the jury before they're on the jury. Failure to protest unlawful evidence. Failure to get to make an adequate case. Arguing for dismissal. Huge things, big and small. Narrative failures, objection failures, evidence failures, witness failures. And again, some things they've done have been good. But let me leave you with the last thing. They moved for mistrial without prejudice. And maybe that's just a defense. Maybe that's just their way of attempting to mitigate what they did. You know, as a backup, if there isn't, I mean, if they don't get mistrial with prejudice and they get a conviction on something, a mistrial without prejudice would be a good thing. But I think given the 19 other things we just went over, we have to point out one thing, which is that if there's a mistrial without prejudice, the process starts all over again. There's a whole other trial. And you have to keep in mind, lawyers are billed for time and lawyers like press. And maybe, just maybe, the explanation for them missing out on these enormous opportunities, missing out on these enormous possibilities for changing the outcome of the case early on and in the middle and at the end, wasn't entirely motivated by their own personal failings as attorneys, wasn't entirely motivated by just not knowing what they didn't know, wasn't entirely motivated by just making a strategic error here or there. Maybe they weren't zealously enough advocating for their client. And maybe, just maybe, they like it that way. Who am I to say? Just an observer. I just want to put this all out there because we're now in day 3 of jury deliberations. Day 4 will be tomorrow. We may get a verdict tomorrow. We might not. Something else might happen. We don't know. But I've watched a lot of coverage of the case. The mass media has not picked up on any of this stuff, hardly at all. The only channel that really has, and a lot of this that I'm bringing to you really comes from him, so I will give him credit, Nick Rekieta of Rekieta Law, and the fantastic panel he's had on his YouTube channel. Look it up on YouTube, Rekieta Law, Rekieta. However, he's been covering the trial so intensely that you'll have a hard time finding where to start in his videos because he's done about 12 hours of coverage for every day of the trial. We're talking 9 hours while the trial is actually going on and then a 3-hour recap at night. So it's a lot to go through. So if this 1 hour was a lot for you, well, he's got a lot more. But if you want to know all the dirty details of the trial as it happened, that's where to go. So that's it, guys. I hope you found this informative. If you like this kind of content, be sure to share it on social media. You can like and subscribe to our YouTube channel, our Rumble channel, like this post on Facebook, share it. All that stuff is really good, really helpful. We're just getting our Facebook page off the ground. We're just getting our Twitter page off the ground. So anything you can do to help promote the channel. If you like this kind of content and you want to see more, this is not the normal stuff we talk about on Rescue Michigan. Usually it's in the field Michigan politics. It's getting involved in active legislative battles that are happening in Michigan. Even if you're not from Michigan, I hope the content is useful for you and your state as far as how the legislative process works. We've done lots of videos talking about the nature of politicians, how to be effective at the Capitol, how to organize a legislative project, how to build and grow a local organization. These are the things that we talk about. We think you'll find them useful. We encourage your participation in this. So once again, if you like this kind of content, please help us promote it and get the message out there, because I don't know anybody else on social media who is a professional political operative talking about how politics really works. You don't get that from the mass media. You don't get that even from the conservative media. And you certainly don't get that from people that don't know what they're talking about because they don't know what they're doing. So as always, I hope you guys have had this, you found this stream informative and entertaining. So as always, thanks for all that you guys do for liberty. And until next time, peace.